Asylum seeker deal. Hello, I'm Kim Landers, continuing our coverage of the High Court's decision on the federal government's asylum seeker swap deal with Malaysia. Now, the High Court has ruled against the federal government's asylum seeker swap deal, throwing into doubt the future of the scheme. Now, the deal had been put on hold following a challenge from two asylum seekers who were scheduled to be among the first to be transferred to Malaysia from Christmas Island. Lawyers for the pair argued Australia could be in breach of its international obligations because it could not guarantee the rights of those sent to Malaysia, a view that the High Court has sided with. The court also dismissed the government's argument that the individual deal ensured the rights of asylum seekers sent to Malaysia would be protected. Under the proposed deal, Australia was to have taken 4,000 refugees from camps in Malaysia in exchange for the Malaysian government accepting 800 asylum seekers who would arrive by boat at Christmas Island. Our political editor, Lyndall Curtis, is in Canberra and she joins me now. Now, Lyndall, this is a major setback for the federal government.
It certainly is. It casts a very big pall over the prospect of the Malaysia deal proceeding, although, as you heard Don Rothwell say, there's potential for the government to rework the deal. But what the High Court found is that the country which the government seeks to send asylum seekers to must be legally bound by international law or domestic law to provide access for asylum seekers to effective procedures for assessing their own need of protection, provide protection for asylum seekers pending determination of their refugee status, and provide protection for persons given refugee status pending their voluntary return to their country of origin or their resettlement in another country. Now, the agreement struck between Australia and Malaysia was not legally binding. It didn't have any force in law. It was rather an agreement, and that's the sticking point for the High Court.
Now, I think a little earlier we heard Professor Don Rothwell, who's from the Australian National University, saying, well, look, the federal government could seek now to amend the Migration and the Immigration Acts, but of course in this parliament to do that they're going to need some crossbench support.
And they're going to need crossbench support in both houses of Parliament, and you'd have to think that putting those propositions into the Senate, they may well not get Green support. The opposition, I wouldn't think, would be mindful to help the government out on this score. So anything they do in Parliament is fraught as well. So and I think even reworking the deal, pushing Malaysia into making these agreements legally binding might be problematic too. So I'm sure the of lawyers try and figure out what they can do to get the Malaysia deal back on track, but certainly there are some very high hurdles for it to jump now. And
Lyndall, previously, before the High Court had delivered its ruling, the federal government had indicated that it was quietly confident that its agreement with Malaysia would stand. Do we have any indication about whether the federal minister, the Prime Minister, anybody from the government is going to respond quickly to this ruling?
Well, the Immigration Minister, Chris Bowen, is in Canberra today. I checked with his office earlier today and they hadn't yet figured out their plans for responding. I'm sure there will be a response, but they will be wanting to go through the full High Court judgment with a fine-tooth comb and talk to their own lawyers about what's possible to do. But certainly it's a setback for the Minister, who at the beginning said he knew that the agreement would be open, that people would try to challenge it legally. But as you said, the government did seem quietly confident. But it appears that its confidence was somewhat misplaced.
And finally, Lyndall Curtis, also very early days for the opposition to be reacting to this. I noticed that the immigration spokesman, Scott Morrison, earlier today was saying that any High Court decision would just be a decision about ministerial powers, not about the worthiness of this particular asylum seeker policy. Do we expect to hear from the opposition as well today?
Yes, I'm sure Scott Morrison will be standing up again this afternoon to comment in this. The Greens' Sarah Hanson-Young is also expected to comment soon.
Lyndall Curtis, our political editor in Canberra, thank you very much.
Thank you.
And if you're just joining us, the High Court has ruled against the federal government's asylum seeker swap deal with Malaysia, throwing into doubt the future of the scheme. Well, today's court decision is the latest development in the government's response to a very difficult policy area. Nick Grimm takes a look at efforts to stop the boats.
Successive have struggled to come to grips with the problem of people attempting to make the dangerous journey to Australia on board leaky boats. Now, many more people seeking asylum arrive on commercial airline flights each year, but it's those images of crowded refugee boats that have posed the biggest political problem for the nation's leaders. It's now been 10 years since the Tampa affair and the sinkings of asylum seeker boats at sea saw the then Howard government adopt what became known as the Pacific Solution, where more than 1,600 asylum seekers who'd arrived by boat were sent to the tiny Pacific island of Nauru for processing. Now, that arrangement did result in fewer asylum seekers attempting to come to Australia, but it was also condemned as inhumane by the United Nations and human rights groups. The election of the Rudd Labor government in 2007 saw the scrapping of the Pacific Solution, but by 2009 asylum seeker numbers were back up again. Efforts by the Australian government to negotiate the establishment of a regional processing centre with Indonesia and East Timor foundered. Then the Malaysia asylum seeker deal was announced in May this year. Under that plan, the Gillard government said it would send 800 asylum seekers for processing in Malaysia in return for accepting 4,000 people once they'd been processed and declared to be genuine refugees. The Gillard government has also signed a memorandum of understanding with Papua New Guinea, which would see the reopening of a processing centre on Manus Island. The finalisation of that deal has been delayed as a result of current political upheaval in PNG. Meanwhile, some refugee advocates have this year reversed their opposition to the former Howard government's Pacific Solution and called for the reopening of the processing centres on Nauru, seeing that, essentially, as the lesser of two evils.
Nick Grimm with that report, and as we've been reporting, the High Court has scuttled the Malaysian asylum seeker swap deal. Our political correspondent Andrew Green is outside the High Court in Canberra. Andrew Green, I know it's just been minutes since the ruling from the High Court. The full bench has been handed down. What can you tell us about that ruling?
Well, certainly this is a devastating blow for the government. It was very confident, as the Minister put it, that it was on solid legal ground with its Malaysia asylum seeker swap deal. Well, the High Court, the full bench of the High Court has disagreed with the government on that matter, and also on the matter of unaccompanied minors being sent to Malaysia. The court was considering whether the Minister essentially acts as a minister or first or a guardian of the children first, and the court has come down in very much the favour of the unaccompanied minors, that the Minister should be acting as a guardian in that question. So a headache for the government today. That doesn't necessarily mean that the Malaysia solution is finished for all money. The government does have a number of options before it in the Parliament through legislation, that sort of thing, but as we have had pointed out to us today, the government doesn't necessarily always have a guarantee when it approaches the Parliament with new legislation. It is in a minority in the Federal House of Representatives.
And Andrew Green, I'm just looking at the ruling here now, and if I can just read from it, it says that the High Court held invalid the Minister for Immigration's declaration of Malaysia as a country to which asylum seekers who entered Australia at Christmas Island can be taken for processing of their asylum claims. Now, there had been a temporary injunction placed on this deal. What has the High Court decided about that? Does that mean that it's permanently on hold now?
Well, there are a number of things that the Minister will have to address. Essentially, what you're talking about are the 300 or so, of slightly more asylum seekers who are currently being held on Christmas Island in limbo while this court matter was resolved one way or the other. So there will have to be questions now that the Minister, Chris Bowen, will have to answer about those specific people. And then for further arrivals, of course, the government was saying with the Malaysia solution that the first 800 who arrived since the signing of that agreement in July would be processed under these arrangements. Well, now that has been placed in jeopardy by this decision of the High Court, so the Minister will have to rule on any further arrivals, what will need to be done for people subsequently arriving, as well as the people already being held on the Christmas Island Detention Centre. And of course the government, as we know, has been exploring a number of options. There's the Manus Island Detention Centre, which was closed when Labor first came to office. Well, the government is now considering its options on that and negotiating with the Papua New Guinea government on that.
And Andrew Green, a little earlier we did hear from Professor Don Rothwell, who is a Professor of International Law at Australian National University. He was sort of explaining his interpretation, his reading of this High Court decision. Does he think that the federal government may be able to try to amend parts of the Immigration Acts and therefore try to revive this deal, if you like?
Absolutely. He says it's really now in the Minister and the Government's court on what it does with the Malaysia solution. It certainly isn't the end of the Malaysia solution forever, but under its current legislation that was used to enact this agreement, that it is, as you say, being declared invalid by the highest court in the country. That now leaves it in the Minister's court, but as we mentioned just before, it is very difficult for the government in this hung parliament, in this minority situation, to legislate contentious issues like this. So we will, of course, hear more from the government later today when the Immigration Minister speaks, but a very big headache for Chris Bowen this afternoon.
All right, Andrew Green, outside the High Court in Canberra, thank you very much for your time.
Thanks, Kim.
And just quickly, we should also mention that this High Court decision was not unanimous. In fact, it was a judgment 5-2. So 2 of the judges on the High Court are dissenting with this ruling, but nonetheless, the majority of the High Court judges deciding that the federal government's asylum seeker deal with Malaysia is invalid, and so therefore they've made permanent the injunctions that had been granted earlier, which means that the federal government cannot send any of the asylum seekers who've arrived at Christmas Island to Malaysia, and nor will Australia be starting to accept some of those 4,000 refugees that we had agreed to take as part of this deal. Moving on to some other news, and security is being stepped up at the Northern Immigration Detention Centre after 2 fires broke out